Bismillahirrahmanirrahim. Rabbi shrahli sadri wa yassirli amri wahlul uqdatam min lisani yafqahu qawli. Through this lecture, I am going to throw light briefly and precisely about the Illegal Dispossession Act 2005, which has undergone different phases while interpreting the provisions of this act by the honorable superior courts of the country. As you people from the legal fraternity, my friends, are aware of the fact that this promulgation of this act was necessitated in the wake of rising crimes and offences by the culprits, through which they encroached upon the lawful rights of the occupiers and the occupants of any immovable property. So it was need of the time that there should be some new piece of legislation, because earlier provisions of the civil law, particularly Section 9 of the Specific Relief Act, through which the suit under Section 9 for possession were instituted by the aggrieved party. Similarly, there was also a provision under Section 145 CRPC pertaining to disputes of immovable property, which was regulated by the magistrate and at its own instance by the SHO concerned, or on the basis of any complaint, any sort of controversy arises between the two claimants of some immovable property. So that in this was the background, and keeping in view this scenario, then the Parliament took into consideration this aspect of the matter. So the law was promulgated in the year 2005. However, after some time, a need was felt by the then Honorable Lahore High Court, and a bench was constituted comprising of Honorable 3 judges of the Lahore High Court, and this whole act was dilated upon and expounded in its different dimensions and angles. But ultimately, and when that was reported in PLD 2007 Lahore 231, having titles Hur Ahmed versus the State. Before further embarking upon this very exhaustive and comprehensive judgment rendered by then Honorable Lahore High Court, it is deemed appropriate by me to just recapitulate the provisions. Those are just 9 in numbers. It is a very small act of illegal dispossession 2005. So in that act, some definition, because firstly, as you know, the scope and extent is covering whole the Pakistan, so it is a federal statute. So court which would hear the matters, the complaint against the violators, against the offenders, that is court of session and court of criminal procedure, wherever needed, is deemed to be applicable. So occupier means the person who is the complainant and basically whose rights have been encroached upon, either that is this should be immovable property, either it's a house, it's a vacant plot, it's a godown, it's some other whatever, but this which is fastened with the earth. So as immovable property have been defined. So property, as I have said, immovable, but the person who has laid his claim and intends to prosecute the offenders who have illegally occupied his property, it is only relatable with the immovable property and not the movable property. So the section 2 of it pertains to the definition clause. So these are the definition with the Now in the section 3 of that act, contains, and basically it starts from the negative connotation. No one would illegally occupy the property of somebody. If he does so, then a private complaint shall be filed. But it is under section 3(4) of the Illegal Dispossession Act and not under the normal code of procedure as the provision under section 200 has been postulated. But it has got, because it's a special enactment, and special act certainly precedes the general law, and that 200 section 200 is provided in the criminal procedure code, being the general law. So, and as far as the cognizance of offence is concerned, because no case is provided in terms of section 154, so this is a distinct special law. The only remedy available with the aggrieved person whose property has been illegally occupied by the accused person, he has since it is a non-cognizable offence, so appropriate remedy provided under this act. So being a non-cognizable offence. Section 5 is of very significance. Through this act, it has been postulated that an inquiry, or rather an investigation, can be entrusted as soon as the moment that that complaint is filed under section 3(4) of the Illegal Dispossession Act. The Sessions Code, either the matter is being dealt with by the additional Sessions Judge, who has been specially empowered under this act, or the Sessions Judge. So he'll obtain a report from the in charge of the police to ascertain prima facie the facts and the allegation leveled against the accused person. But similarly, some time stipulation has also been given under the act. Firstly, the investigation shall be conducted by the SHO, by the in charge of the police, within 15 days, but with valid good reason, the time can be extended with the permission by the court. But this 60 days have been provided for conclusion of. So this is on the day-to-day basis, so that the aggrieved person could be granted whatever is the appropriate relief after reaching at a conclusion within 60 days, but subject to peculiar circumstances, that too can be extended. But under section 6, the pause is also when prima facie court is convinced about the claim of both the parties whose possession exists at the time of filing of the private complaint. So just as a substantive relief, till the conclusion of the culmination of that trial in hearing of that complaint case, the order of the attachment of that property can be passed with the order of the court. So, but there are another provision under section 7 of the Illegal Dispossession Act, through which the interim relief, interim possession can be restored to the person, to the complainant, if he has been able to convince the court that how he was dispossessed from that property. But that, as connotes from the word interim, it would be ultimately its fate would be decided whether the complaint is dismissed or complaint succeeds, and the accused persons are awarded punishment, which has been provided under the law to the extent of 10 years, with award of compensation to the complainant as contemplated under section 544 of CRPC. So, and the ultimate relief, the delivery of possession, and it has also been provided in the last section of that act, and act under question 9, the applicability of the code of procedure. What happened? at a very, in matter and came up, any aggrieved party when approached the Honorable Lahore High Court, the whole this law was expounded, was dilated upon by the honorable judges, and they reached at the conclusion that because earlier some provisions under Section 9 of the Specific Relief Act 1877, the provisions as I have referred above under Section 145 CRPC, dispute related to real property, and some other provisions available under the Pakistan Penal Code 1860, the general criminal law in vogue in the country, wherein some section like criminal trespass, but there the punishment provided in that probably to the extent of 3 months. So since it had not these provisions and these laws either on criminal side or civil side were not fulfilling the actual requirement, so there was a free hand to the swindlers, to the land grabbers, to deprive the actual occupier, the lawful owner of that very property in a very blatant and flagrant manner, which ultimately that new special and law was enacted. But when the matter came up before they took into consideration the existing laws, as I have referred above, but some parameters were laid down that a blanket cover cannot be given to any aggrieved person. He may put his claim to prosecute any offender on the basis of bald allegation or with generality. So what was ultimately decided and exhaustive elucidation was made by the honorable judges that the person against whom this allegation are being leveled was one person or two persons or more, the accused person of that very complaint under Section 3(4) of the Illegal Dispossession Act, they must have those criminal antecedent and credentials that they belong to some group of land grabber, some property grabbers and mafia. So they must have this sort of history. So this was their perception. Keeping in view this aspect of the matter, there is a strong probability and possibility of prosecuting the person with some other ulterior motives, and because quite reasonable punishment to the extent of 10 years with compensation has been provided under this law. So almost through this judgment, the title Zohar Ahmad I have said, this whole law was made almost ineffective and dysfunctional in a way. But when some other aggrieved person either was summoned at that very initial stage, when prima facie, after obtaining the report from the SHO or otherwise, whoever was the aggrieved, and they approached through filing the appeal if somebody was convicted, then the Honorable Supreme Court was found divided through as many as 5 judgments by different benches of the Honorable Supreme Court of Pakistan. I would say one set of the judges and through their judgments told the line of on the basis of that very judgment of the Honorable, So first set of the judgments, those were these matters were dealt with by the Honorable Supreme Court of Pakistan. So it is titled report Muhammad Akram versus Muhammad Yusuf, reported in 2009 SCMR 1066. Second was Mumtaz Hussain versus Dr. Nasser, reported in 2010 SCMR page 1254, and Shahabuddin versus. So through the cited three judgments, the Honorable Supreme Court of Pakistan took a different view, absolutely distinct from the judgment of Zahur Ahmed on this Illegal Dispossession Act. So they held and observed that merely on the basis of this interpretation and connotation that the accused person must have the criminal antecedent and their past history must indicate and decipher that they are habitual of, in other sense, they are habitual of committing such like crime. So in this view of the matter, at least the horizons and avenues of the benefit of Legal Dispossession Act 2005 are again opened up, and the law was activated in its true in its latent spirit and in its true context, as it was and as its preamble suggested and proposed and made it the need of the hour. But again, some of the honorable benches of the Supreme Court of Pakistan almost agreed with that the Hurama judgment. So those judgments are first one, Bashir Ahmed versus Additional Session Judge, PLD 2010, Supreme Court 661, and Habibullah versus Abdul Mannan 2012, SCMR 1533. So this was the emerging scenario, having operative two sets of judgments, and keeping in view this particular feature and development with regard to interpretation of the different provisions of that very Act of 2005. Other petitions were filed before the Honorable Supreme Court of Pakistan, but where from the judges seized with the matter of the complaint filed under the provisions of Illegal Dispossession Act 2005 will be dealt, and what are the guidelines for them. So the first set of, as per first set of the three judgments referred supra, the Honorable Supreme Court of Pakistan, a larger bench was constituted, comprising of 5-member bench, and judgment titled Musammad Gulshan Bibi and others versus Muhammad Sadiq and others was given, reported in PLD 2016, Supreme Court 769, on 15th of June 2016, about 2 years back. So this controversy was set at rest. That the three judges, and they, however, I can't comment because we have all the respect and deference for the honorable judges of the Superior Court, either of the Honorable High Courts or the Honorable Supreme Court of Pakistan. But a distinction was drawn through this larger bench by the Honorable Supreme Court of Pakistan that the earlier judgments rendered by the Honorable Supreme Court, those are 3 in number, are said to be the good law with regard to interpretation of the provisions of Illegal Dispossession Act 2005, and the other 2 judgments are the bad law. So this was the scenario. And the Honorable Supreme Court, through this larger bench, took into consideration the popular situations of on the ground, of the society, of increasing number of cases of such nature, which ultimately and wisdom and sanity prevailed in the minds of the legislators when this law was introduced. The working paper was prepared, draft was prepared, and after certainly much deliberation and thoughtful consideration, ultimately this law was promulgated. But so they were of the view that merely on the basis of this, as initially observed by the honorable judges of the Lahore High Court, through that judgment of the reporter 2007, PLD Lahore, in the Zohar Ahmad case, as well as by the other 2 benches of the Honorable Supreme Court of Pakistan. So how can this inference be drawn just to deprive the complainant, the genuine occupier, whose property has been grabbed? So they were also of the view, the honorable then the 3-member bench, and as well as the 2 benches of the Honorable Supreme Court of Pakistan, who were unison on the regarding the interpretation of this aspect of the matter, the having the credentials and the criminal antecedent prior to. So how is it possible? May a person may come forward while committing the offence? At the most, there can be mitigating circumstances if such like offence has been committed, but there is also a safety valve. That is why that offence has been made non-cognizable offence, and cognizance is taken after the filing of that very complaint. Similarly, another precaution has been taken by the legislator, and this is the intent and objective of the legislator, that the cases should not be heard by the magistrates, like Magistrate Section 30. Or my perception, therefore the session courts have been vested with the powers to hear such like complaints against them. Even otherwise, I have got some and although to precisely the Honorable Supreme Court of Pakistan, through this authoritative judgment which holds the field, have also thrown light on this very vital issue, because these sort of crimes are always committed by rich persons, influential people, feudal lords, the big swindler and culprits. They might be having even their own cronies and henchmen, and they remain. They remain behind the screen. They don't disclose their identity. So it becomes very difficult even for the complainant Or normally, the property icons, the big builders, the people who are running the housing societies, especially in big towns, big cities, and there are lot many techniques and modes and devices to deprive the people from their properties. Let me refer here. What they do if somebody is sitting abroad for earning his livelihood, unfortunately fell prey to these land grabbers in a very organized manner, and started paying the installments for purchase of the plot. But if he comes after 2 years, 3 years, he comes to know that somebody has occupied, and then he is advised. So this is such a engineered crime, which it too was the need of the hour. And even I believe maybe many years one could not come to know. But prima facie, if the investigation. So this is certainly this sort of special enactment was required to be promulgated, and its fruits must go to the affected people, to the persons who have genuinely been have become the victims, because they purchase some plot after hard labor, by saving the income bit by bit in many years, and somebody in a very planned manner has committed this sort of crime. So this is keeping in view this aspect of the matter. I would say yet there is a greater need of expanding, rather bringing some amendment. Only police officers are in charge of the police under Section 5 of the Illegal Dispossession Act should be not relied upon. He may join hands with the culprits, with the accused person who have occupied some precious land. The scope should have been expanded, by my perception, by bringing some amendment, or specifically the revenue officer, some man of impeccable character who is serving with some intelligence agencies, with having some expertise in the revenue laws, and even the revenue officer. We have to with the revenue codes under Section 1967, maybe a person can seek redressal of his grievance, but that has not served the purpose. Another, it can also be focused to particularly after the clarification of the actual provisions of the Illegal Dispossession Act 2005. So this authoritative judgment reported in ELD 2016, Supreme Court 769. The data can be collected after even 2016. There was yet 2 years have passed. In which city, in which area, whether mainly of rural areas or that of urban, how many such complaints have been instituted, what is the ratio of decision, either the accused persons have been acquitted or the complaints have been dismissed. So it would be more beneficial to grasp the actual scenario, actual situation on the ground, and whether the provisions as contemplated under the Act, like interim possession, and ultimately on the basis of that very decision, whether have been restored, how many such at the appeal stage matters have been pending in form of writ petition before the Honorable High Court. So I would say this is this with these suggestions, the scope can be extended. Merely on SHO should not be relied upon. There is every possibility that good people, character good people, there is no dearth of such life. But at the same time, particularly for committing such like crimes, occupying somebody's property worth of, let's say, 3 million, 4 million, 5 million. So they do, prior to committing such like crime, they get they form a group. Maybe they are using some very people from the downtrodden society, from the poor families who are jobless, who have also have become their victim because of their own needs. If they don't have the employment, they may not be understanding the intricacies and technicalities involved in such like matters. If somebody says, okay, the vacant plot is lying there, go with group and some you must carry the weapon, the relevant police is also on board. They'll not cause any disturbance. So this is, if in its true perspective, this law is implemented, its benefit, it can be very much advantageous to the innocent persons. But what is required to be examined very minutely, that how many such like cases have been dealt with by the courts with their ultimate decision, and betterment can be brought more and more. Thank you very much.